Right, good afternoon everyone and welcome to this webinar hosted by the real estate litigation team at Walker Morris. This webinar will consider a number of topical issues in the commercial property market, but before we start I'll do some brief introductions and some housekeeping. I'm a director at here at Walker Morris. I'm also joined by my colleagues Couth and Jordan Rawlings. The plan is that myself and Lewis will run through the three topics and it talk for around 6 or 7 minutes for each topic, and then there's going to be an opportunity for Q&A at the end. So please do send through your questions to Jordan during the course of the webinar and we'll do our best to answer them. The plan would be for the webinar to finish at around 12:45, but we'll see how we go with the Q&As. It's fair to say the last 6 months has been the most eventful in my time. A lot of challenges for all of us involved in the commercial and residential property market. But as a property litigator, you're spoilt for choice when it comes to choosing topics to speak about. It's very much a case of where on earth to start, as the last 6 months has probably been the busiest time for property litigators. There has been an awful lot of coverage and commentary about the various COVID-19 restrictions on landlord and creditor remedies, and therefore we wanted to choose topics perhaps that had seen less coverage, but were still really important to landlords, tenants and developers alike. So sort of the order of events, as it were, I'm going to be dealing with insurance claims in the pandemic and the issue of rent. I mean, almost all tenanted properties will be insured, and the question we're posing today is, can the insurance policy provide a route to plug in the rental voids that so many landlords are experiencing? Lewis is going to be considering the question, what is a leasehold covenant worth post-COVID? A question we are often asked at the moment by landlord clients in light of the surge in CVAs and restrictions on enforcement. Lewis will consider the enforcement of leasehold covenants and in particular enforceability of guarantees, which are ever more important. I'm then going to also discuss the changing face of the high street. Clearly it's a watershed moment for the high street, and it's going to have to evolve from its predominantly retail profile. I'm going to consider alternative uses and the ability of property owners and tenants alike to secure a relaxation of freehold and leasehold restrictions on use through applications to the Lands Chamber under Section 84 of the Law of Property Act 1925. Right, so the first section of the webinar is talking about business interruption insurance, and as the slide says, we're posing a question that is insurance a solution to the rental voids? Well, in March 2020, when Rishi Sunak was announcing unprecedented range of measures that were designed to support businesses through the pandemic, he said that for those businesses which do have an insurance policy that covers pandemics, the government's action is sufficient and will allow businesses to make an insurance claim against the policy. However, in practice, what I've seen is many landlords experiencing difficulties in successfully asserting claims against insurers for business interruption losses. So I'll briefly touch on, well, what is business interruption insurance, and I won't take too long on this. I'm sure you're familiar with it. Business interruption insurance is usually provided in combination with property insurance. The trigger for cover under the standard wordings of those policies is usually physical damage to the insured property that causes a loss of revenue or an increase in operating costs. So for example, if a business cannot operate because its premises are damaged by fire, the resulting loss of income or increase in costs may be covered under the policy. However, this type of damage may not respond where losses are caused by an infectious disease, or indeed actions taken to combat it. However, what you might see is a lot of insurance policies including extensions that widen the scope of events that will trigger business interruption cover. So the obvious question is, well, what extensions might be relevant? And in my view, there are two main types of extensions to look out for in any policy. You've got the what's called a specified or notifiable disease extension, And this essentially provides cover for losses caused by infectious diseases, usually where there have been cases of the disease at the insured premises or within a specified distance, and that can range. Some policy sets out a list of specified diseases that are covered. However, since COVID-19 was only identified in late 2019 or early 2020, it's unlikely to be named as a specified disease. Other policies provide cover for losses caused by notifiable diseases, and helpfully on the 5th of March, the government formally designated COVID-19 as a notifiable disease, which was in part to facilitate insurance claims by businesses affected by the virus. Another extension to look out for is what's called a sort of non-damage denial of access extension. And this provides cover when access to a business's premises is hindered or prevented by something other than physical damage to the premises. The policy will set out what events causing the prevention of access will trigger the cover. But as an example, many policies include cover where access to premises is prevented on the order or advice of the government or other statutory body, which obviously is relevant at present times, especially during the lockdown. So when can these extensions be used? There has been some debate over when the relevant extensions can be used and whether insurance policies were ever intended to cover losses arising from pandemics without express wording to that effect. And I'm aware of a number of insurers that are rejecting claims on this basis. However, I've had advice from leading counsel on this point, and whilst every case is fact-specific, the general tenor of that advice was positive. Essentially, provided a landlord can tick the boxes under the policy, for example, that COVID-19 was present within 25 miles of the insured property, then the policy is engaged. There may be no need to show damage to the property itself, but there does need to be a causal link between COVID-19 and the loss suffered, which in my view is not particularly difficult given the impact it has had on tenants and their ability to pay rent. So what practical steps should landlords be taking? Well, firstly, I think it's notifying their insurer immediately of any event that may give rise to a claim because there'll be specific notification obligations under the policy. So therefore, it's important that landlords speak to their brokers as soon as possible if they've not already done so, and that the insurers are put on notice of any potential claim. I mean, insurers should be notified even if you're not sure whether the policy will provide cover or if it's not possible to even quantify the losses that will be suffered. Landlords should ensure that they create and maintain document evidence that they'll need to support any claim. Obviously, the evidence required will depend on the part of the policy the claim is made, the wording of the policy and the types of losses, but it's likely to include, in my view, at least financial records showing the loss of revenue, evidence of any additional expenditure incurred as a result, and records of decisions that may have been taken responding to the pandemic and that may have had an impact on the financial performance of the business. I also mentioned there on the slide actually about the FCA test case, and the FCA, that's Financial Conduct Authority, is currently bringing a test case that invites the court to determine the applicability of certain non-damage extensions to COVID-19 and how they apply. In that case, there are 17 disputed policy wordings issued by a number of insurers. Some of those insurers are actively participating in the test case, and we're expecting a ruling on that case by around mid-September. So far as that case is concerned, it's a wait and see. But I suppose, as a conclusion just on this section, given the recent measures from the government, this has left landlords in the sort of unsatisfactory position, really, of bearing a significant burden as a result of the impact of COVID-19. However, whilst a number of insurers are suggesting that insurance policies do not cover pandemics, what I'm hoping you sort of just from this brief talk is this is not always the case. And I'm currently dealing with these very issues now with a number of insurers. And obviously, should anyone listening to this now wish to discuss this in more detail, then I'm more than happy for you to contact me after this webinar, and we can obviously discuss the issues that are raised in more detail. I'm now going to pass over to Lewis to take on his section.
Oh, sorry, we're going to have some technical problems today. As we've seen for a while now, company voluntary arrangements, CVAs, have become fashionable, especially in the retail and casual dining sector, where for a number of years companies have been hit with financial pressures of online shopping, increased overheads, austerities and a saturation in the market. It appears that every year we hear about another infallible giant falling by the wayside, and over recent years we've seen high-profile CVAs that included the likes of Debenhams, Jamie's Italian, Mothercare and Toys R Us. The economic impact of COVID-19 means that many businesses are likely to have suffered and are likely to continue to suffer severe financial distress. That's why we're seeing a new wave of CVAs in the first 7 months of 2020. Indeed, I understand today that Pizza Express are about to propose a CVA. I think one of the biggest surprises for landlord clients has been the speed in which seemingly solvent or successful solvent companies have been rendered insolvent by the financial pressures caused by COVID-19. And as a result of those cash flow challenges, have looked to propose a CVA. For example, we've been recently advising a number of landlord clients in relation to the CVA proposed by Travelodge, who in 2019 made earnings of 129 million on revenues of over 600 million. And you can see from the slide that they were proposing to open stores left, right and centre. And yet only 6 months later, in June of this year, they proposed a CVA to its creditors where many of its landlords faced reduced rental income or indeed no rental income at all for up to 2 years. For a tenant, a CVA is a useful restructuring tool. It's a consensual process whereby a company seeks to compromise some or all of its debts with the agreement of its creditors. From a landlord's perspective, a CVA will often be used to reduce the rent for a period of time, typically about 36 months in duration, sometimes shorter. The CVA will often categorise the leases into different bands, with the tenant proposing to pay up to 100% for the good performing sites, the ones it wants to keep, and sometimes down to nothing for the poor performing sites. The CVA may also look to compromise other liabilities such as dilapidations. To be passed, the CVA requires at least 75% of the creditors of the company to approve the proposal, and if approved, it creates a binding agreement upon the company and the creditors who are able or entitled to vote at the CVA meeting. They will then be bound by the proposal. This means that in one single stroke, a tenant is able to reduce its liabilities under the lease. A tenant is likely to say that if the covenant to pay rent in full remained, then the alternative is liquidation. And the tenant will say that the CVA provides a better outcome to the landlord than liquidation, despite the compromises being inflicted upon the landlord. However, the question that landlords have been asking us, and going back to the question posed, is what is the benefit of buying, for example, an investment freehold to rely on an income stream if a tenant is simply able to enter into a CVA, with the effect being that the tenant is able to rip up the lease and have the terms on which they let their properties varied against their will? It's a pertinent question, and I think the reality is that under the current CVA regime, the option is out there for tenants. In the current climate, I don't think there's going to be any appetite to make legislative changes. As such, landlords are going to face the risk that leasehold covenants are potentially either of less worth or even worthless. One solution, if available to the landlord, is to consider enforcing the covenants against the guarantor. However, the concern that's been raised by a number of landlord clients recently, and in fact earlier today, will a CVA release or limit enforcement against the guarantor too? As a general rule, a guarantor's liability is no greater and no less than that of a principal, in terms of amount, time for payment, and the conditions under which the principal is liable. Accordingly, if a creditor, in our case a landlord, releases the principal debtor, i.e. the tenant, from the debt or obligations by a valid and binding agreement, then the surety ought to also be discharged. On face value, therefore, if the landlord is agreeing to a reduced rent under the CVA, then the landlord ought only to be able to recover the reduced rent from the guarantor. However, under a well-drafted lease, as well as a guarantee, the lease ought to impose a separate and independent indemnity obligation, and the guarantor, including in relation to any loss flowing from the lease being varied, and the guarantee ought to seek to ensure that its liability shall remain in full force and effect, notwithstanding variations to the terms of the lease, whether through a voluntary arrangement or otherwise. Just over the next slide, I set out the sort of indemnity that you would expect or want to see in a lease, and following this talk we'll circulate a bit of a briefing note, and we'll include those example provisions in that, so I won't go through them today. In a contract of indemnity, unlike a simple contract of guarantee, a primary liability falls upon the guarantor. The liability on the guarantor is wholly independent. Therefore, this would give the landlord protection and would mean that the landlord is entitled to enforce the covenants in full against the guarantor, irrespective of whether the CVA proposals seek to compromise the covenants. In those circumstances, and referring back to the question, what is a leasehold covenant worth post-COVID? If the lease is supported by a contract of indemnity, then the landlord can be confident, or ought to have at least a degree of confidence, that it does have a worth, as the CVA is unlikely to prevent the landlord from seeking a full recovery from the guarantor. There has been a handful of cases, including the one on the slide there, Prudential Assurance versus Powerhouse, where the CVA proposed seeks to interfere with the rights against the guarantor so that the landlord receives less than 100 pence in the pound. The likely scenario this is going to happen in, or like scenario when this is going to arise, is where the guarantor is a parent company of the tenant, and therefore the tenant wants to not only release itself, but its parent company too. What can be taken from this case is that if the CVA does propose to release the guarantor under the proposal, then it is very likely to be unfairly prejudicial to the landlord. And with the effect being that it ought not to be binding upon the landlord. So just going on to some of the practical steps. So if we do have a guarantor that we can look to, then Section 17 of the Landlord and Tenant Covenants Act 1995 provides that landlords must serve a notice on the guarantor of its intention to recover fixed charges. So that's rent, service charge, insurance rent. The notice must be served within 6 months of the charge falling due, and a failure to do so can provide a complete defence to the guarantor. So just in summary, the COVID-19 pandemic, in tandem with the current CVA regime, means that landlords do face the real risk that the leasehold covenant has the potential to have little or no worth. The glimmer of light I would offer, however, is that we are seeing clients have real success in recovering liabilities where there is a guarantee in place. I'll now hand back virtually to David.
Yeah, thanks, Lewis. I'm just going to deal with the third and last topic, which is the change in face of the high street, and as I said on the side, sort of unlocking value in your portfolio via alternative uses. The death of the high street has been prophesied for as long as I can remember, but you only have to walk into any city centre at the moment, and it paints a very gloomy picture. Clearly, the predominantly retail profile is unlikely to survive, and I think COVID-19 has accelerated the transformation retail was already undergoing. With more people using online shopping than ever, high streets will have to become more than just a place to shop. There'll need to be a diversification, including more housing and alternative uses. I saw a report recently actually from the Social Market Foundation that said the UK could build at least 800,000 homes if vacant retail space was converted into residential property. The think tank suggested that the decline of traditional high street shopping is inevitable, and I think it's difficult to argue against that view. I also saw an article in the FT a few weeks ago that was discussing McCarthy and Stone actually looking closely at opportunities to buy up commercial property in city centres so that they can turn it into housing for elderly residents. And then we know the government is considering relaxing government is considering to relax plans around the conversion of commercial buildings to residential use. And some investors appear confident the legal changes of use can be implemented with ambitious mixed-use developments that have already been set in motion and that incorporate commercial offices, residential homes, leisure spaces into what were previously a retail-dominated site. So all of that as a sort of sad property litigator that I am, I thought, well, what about the freehold and leasehold covenants which restrict use to retail or even bar residential use? I mean, they are going to get in the way of the much needed high street revolution. But what I'd say to that is, well, don't worry, because help is at hand in the form of Section 84 and the Law of Property Act 1925. For those of you unfamiliar with the workings of Section 84, it provides the upper tribunal and the lands chamber with a jurisdiction to modify or discharge covenants to permit alternative use. It applies to any restriction, however, so not just use, so it can apply to restrictions on alterations and alienation as well. I mean, the existence of Section 84 means that freehold owners and tenants alike are not simply at the mercy of those parties with the benefit of the restrictions in question. You know, i.e. they can't be held to ransom. The beauty, I suppose, of a successful modification or discharge application is that would bind the world, which is great, as you often find that it's not easy to identify all the beneficiaries of freehold covenants in particular in order to get releases, for example. I've prepared a short slide there that just sets out the grounds that can be relied upon under Section 74, and there's essentially 4 grounds. However, more often than not, the most common ground being used is ground AA, which, as it says on the slide, it impedes some reasonable use of the land. In order to get home on this ground, however, I mean, it does require a definite scheme of development and planning consent to be obtained if required. The applicant will need to show that the covenants do not secure practical benefits of substantial value or advantage to the beneficiaries. But again, the one really important positive from this is that this provision, it's been decided by the courts that eventually the ability to extract a ransom is not a practical benefit because it has nothing to do with the use and amenity of the benefited land. I mean, compensation can be awarded to the beneficiaries on a successful application, but this is typically modest. Because if it was substantial, then it would obviously follow that the covenants did secure practical benefits of substantial value or advantage to the beneficiaries, and so by the very nature, the application will fail. It's also really important and sometimes forgotten, I suppose, that Section 84 applies to leasehold covenants and not just freehold covenants. However, for leasehold covenants, the lease has to have a term of more than 40 years and there's 25 years expired. Now, in my view, a lot of city centre properties will be held on long leases, so Section 84 can assist in the face of a beneficiary seeking to object to the scheme, or more likely to secure a ransom for the release of the covenant. The jurisdiction, as I said, applies to user, alterations and alienation covenants, all of which may require amendment to accommodate the proposed scheme. The government has also introduced a suite of new permitted development rights, which will apply in England, and I've set them out on the slide there. I mean, they're intended to take effect over the next few weeks, and some are enforced now as of the 1st of October, as you can see. So I don't propose to go through those. However, what I would say is, I suppose, the permitted development rights simply provide a potential route through planning control. And in my view, there's still a numerous other factors that have to be considered, including building regulations, listed building control for home extensions. There may be rights to light, ownership of airspace, and as I say, whether freeholders or leaseholders will be building in breach of any covenants. And again, this is where a Section 84 application can play its part. It's also important to note that anyone on the end of an injunction seeking to prevent development for breach of use can invoke Section 84 and have the injunction application stayed pending the outcome of the Section 84 application. Section 84 applications have become more popular in recent years. Certainly, they're more well received in the last 5 to 10 years, in my view. The tribunal process itself is more streamlined and cost-effective than, say, court proceedings. And I can only see them becoming more popular as our city centres obviously evolve. Again, if anyone's considering a scheme which would involve a potential breach of restrictions, then, as I say, the team here at Walker Morris would be more than happy to talk you through the Section 84 process and whether it might assist you. That's the end of my section and the webinar generally, but obviously it's now time for some Q&As. And I will pass over to Jordan just to read out some questions.
Thanks, both. Yes, some interesting topics, and we've had a few questions come through. So I'll give David a bit of a break since he's been speaking there. So just one for Lewis. If in relation to a claim against a guarantor, what's the position if the guarantor isn't good for the money either?
I hope you can hear me now the first time round. Yes, good point. I suppose the first problem, and stating probably the obvious, is that it may mean that there is little prospect of recovering any liabilities from the guarantor either. I suppose the other points to think about, if we're going to have some concerns about the financial position of the guarantor, first is that if we serve the notice on the guarantor, who then pays, they'll be entitled to an overriding lease. So do we want them as a tenant, especially if the guarantor is in a worse financial state of affairs than the tenant? And that might be especially so if it's a short-term cash flow problem for the tenant. I suppose secondly, the other concern that might arise is that the service of the notice is probably going to act as a waiver of the breach and therefore may prevent us from forfeiting the lease. But whether or not we'd want to forfeit the lease in any event is and leave us with the rates is probably a separate issue. So yes, before we do anything, it's best to do some homework on the guarantor. I appreciate it doesn't provide a sort of magic wand answer that how can we extract the money, but that hopefully answers the question anyway.
Thanks, Lewis. And then for David, I guess, on business interruption insurance, would a tenant under their business insurance policy have a similar extension to claim back rent where they've had to vacate premises as a result of COVID?
Well, I suppose what I would say is it's obviously going to depend on the wording of the policy, but in terms of an extension to claim back rent specifically for a tenant, I would be surprised. I would expect it to see more in landlord's policy that is relevant to a specific loss of rent extension. If a tenant has a business interruption policy itself, then generally I'd expect that to be covering its loss of revenues. Indeed, actually, I'm dealing with a case at the moment, not COVID related, but water damage related, and that is exactly that. It's a business interruption policy for a tenant, and the tenant is effectively covered for the loss of revenue whilst the premises were out of use effectively. So as I say, I'd be surprised if it covered back rent, but it would need to undertake a review of the policy to confirm.
Thanks, David. And then just sticking with you, David, on the Section 84 application point, just had a question through what are the sorts of costs that would be involved and how long does that process take?
Yeah, in terms of the process, as I say, it's fairly streamlined, certainly more so than court proceedings. So I think with a fair wind, I'd be saying probably suggesting 9 to 12 months. Costs is a difficult one because I'm not seeking to shirk it, but I think it does depend on the number of beneficiaries, for example, that can be identified because they'll be named as respondents effectively to that application, which will naturally drive up costs and equally the specific issues that are involved. But I would say it's something that would run into the tens of thousands of pounds rather than thousands of pounds, if I can put it that way. But obviously, depending on the development, that may be unlocking a significant amount.
Thanks, David. And then, Lewis, just on the guarantee point again, from a tenant's perspective, if a CVA is voted through but the guarantor wasn't party to it, are they, as in the guarantor, still liable, or does that fall away?
A simple answer and short answer hopefully is yes, in terms of hopefully if you've got that contract of indemnity, which I'd expect most well-drafted leases to include, then there is that primary obligation available. Sorry, that's short and sweet.
Oh, thanks, Liz. And then just kind of to follow on from that, can a CVA prevent the landlord from forfeiting the lease?
Hopefully providing a simple answer, no. A CVA can't vary a lease to prevent a landlord from forfeiting the lease. So most well-drafted leases, again, will include a right for the landlord to forfeit the lease if the tenant takes steps in connection with a voluntary arrangement or is insolvent. Or it may include a keep open clause, which may apply if the tenant has actually ceased trading. If any of those provisions apply, then the landlord will be entitled to will retain its right to forfeit the lease. However, I suppose going back to my first answer is whether or not a landlord wants to forfeit in the current climate is a separate question.
Thanks, Lewis. And then one for David again, just on the test case in respect of the insurers. What do you expect to happen if the insurers were to lose that test case?
Well, I think I'm expecting the insurers to lose. Actually, I suspect the judges in the first instance, anyway, will go with the FCA on the points they've raised. That's my thoughts on that. But if the insurers do lose, my understanding is that they will be appealing. And then it's going to be expedited to the Supreme Court, and I think that is due to be, if that process goes through, I think that will be heard in November, with, I suppose, a judgment probably being given at the end of the year or more likely early next year.
Thanks, David. I think that's all the questions we've had through. So don't know if David, if you want to do a bit of an outro.
Yeah, thanks, Jordan. Yeah, I mean, hopefully everyone has found that useful, and obviously thank you for your time in attending the webinar. As I say, by all means, our contact details are on the slides there. We will be following it up with a briefing note, and I believe there will be a recording as well of the webinar so that we can circulate it round. But what I would say is if any issues are pertinent to yourselves and you think you want to have a further discussion with us, then by all means, please do contact myself, Lewis or Jordan in relation to that, and we'll be happy to run through any points. Thanks very much.